Hello everyone and welcome to the channel Ontario Law and the Older Person, and we're going to be talking about powers of attorney, and this is the first video of many about powers of attorney and other kind of decision makers because that's a very big topic. Now in this video I will be addressing some of the laws surrounding powers of attorney. I'm not teaching you how to draft one, and obviously every adult should have a power of attorney. Usually people leave it until their later years. So that's why it's specific to older people. The information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decision should be made based on this material. Any viewer who needs legal advice should contact a lawyer. And again, I am going to make a plug for lawyers here. If someone can possibly afford it, they should pay a lawyer to draft their powers of attorney. These are extremely significant documents that give others a lot of power over your life. Examples for general use powers of attorney forms online can be misleading. And I once listened to someone talking about who they were choosing to give these powers to, and it had disaster all over it. It's going to be a mess. But I couldn't say anything. And yes, this video is going to be all about the statutes. It could be dry material. Hopefully I'll make it informative enough to be worth your time. I do think it's important to know some of the bones when it comes to the law in order to understand how powers of attorney work. It is a longer video, so hope you can stick with me. In Ontario, we have three kinds of power of attorney, and I'm going to go through all of them. We have the general power of attorney for property, the continuing power of attorney for property, and power of attorney for personal care. Now, different provinces and territories will have similar kinds of documents, but different titles and might be different in what kind of powers they relay. I'm not thrilled with the use of the term living will in Ontario. It's not referred to in a statute. It's basically the same thing as a power of attorney for personal care, and the term is used by lawyers in Ontario, and they will draft documents called living wills. And I'm not saying they're not valid or binding. My issue is that powers of attorney and wills are completely different documents, and some people confuse them or confuse the kind of power that comes with them. Some think that powers of attorney continue after the person has died, and they don't. So that's why I'm not thrilled with this particular phrase. So this is the first step in figuring out what these documents are. This is from the eLaws website, and here's the name of the statute, Powers of Attorney Act, so on. It's Ontario, of course. So this is section 2 from that act. A general power of attorney for property is sufficient authority for the donee of the power, or where there is more than one donee, for the donees acting jointly or acting jointly and severally, as the case may be, to do on behalf of the donor anything that the donor can lawfully do by an attorney, subject to such conditions and restrictions, if any, as are contained therein. So how do you like that language, right? It would make almost no sense to anyone who doesn't have a chance to pick it apart. And don't blame lawyers. Politicians draft this stuff. But I'm going to break down some of it, not the entire thing, but what I think is relevant for the purposes of this video. Okay, so this isn't actually part of that language, but it's important, I think, to know. The general power of attorney for property is only effective while the person granting authority has capacity. So if I now have a power of attorney made and I'm giving someone else the right to manage my property, well, I have capacity now, but if it turns out I lose capacity, then that document is void. And reflecting the language in this section, donor is the person granting the authority to act. So in my case, that would be me. In other locations, it's grantor, just to make things difficult. The donee is the person receiving the authority to act, and in other places, it's grantee. And you can have more than one donee or grantee. Now, multiple donees may be required to agree on decisions or act separately depending on the drafting of the document. So maybe you want to have your donees agreeing on decisions. So they have to act jointly. Or maybe you're leaving them free to make their own decisions independently of each other. They don't have to agree, and it depends on the drafting of the document. It can be very complicated. The document can specify exactly what kind of financial decisions can or can't be made. Donees can't make wills on behalf of the donor, and the power of attorney evaporates once the donor dies. So even though they haven't lost capacity, of course, once they have passed, power of attorney is no longer in effect. Now you would think that a statute called Powers of Attorney Act would give you all the information you need about all the powers of attorney, and you would be wrong. To get more information, we have to go to the Substitute Decisions Act. And this is a very long statute, and it talks about a lot of different ways someone can end up making a decision for someone else. So I'm going to be picking out only little sections here or there that are most relevant for the purposes of this video. So we're going to talk about presumption of capacity. This is from section 2, subsection 1 of that statute. A person who is 18 years of age or more is presumed to be capable of entering into a contract. Now, this applies to powers of attorney, but also applies to pretty much anything involving a decision relating to assets. And this is where ageism can kick in, because too many people decide someone is lacking capacity for reasons they wouldn't apply to a younger person. And then we have same, subsection 2, a person who is 16 years of age or more is presumed to be capable of giving or refusing consent in connection with his or her own personal care. So it's just interesting to contemplate why there's a younger age when it comes to personal care than entering into a contract. Now, this doesn't mean you have to be 16 before you can make health decisions. We've all heard of people younger than that deciding on whether they'll take treatment for cancer, like very serious decisions. It's just that once they reach the age of 16, you assume that they have capacity, whereas you wouldn't need to at a younger age. There'd be more kind of testing and questioning to make sure they know what they're doing. Subsection 3. A person is entitled to rely upon the presumption of capacity with respect to another person unless he or she has reasonable grounds. And reasonable grounds is a phrase you're going to hear again and again in law. Reasonable grounds to believe that the other person is incapable of entering into the contract or of giving or refusing consent, as the case may be. So this is the exception to the presumption of capacity. What reasonable grounds might be is determined by the context. So a psychiatrist evaluating a patient will have a higher standard to meet, yes, this person has capacity or not, than a bank employee selling a mortgage. So what is the background, who's making the evaluation, and what are the circumstances? There will be wild differences of opinion depending on all of those factors. So statutes are divided according to parts. So the part will be like the broad subject, and then the sections will be the finer details within that section. So here we have application of part. So it lets us know a new part is starting. Section 4, this part applies to decisions made on behalf of persons who are at least 18 years old. And then section 5, to exercise a power of decision under this part on behalf of another person, a person must be at least 18 years old. So basically, if you are making decisions for someone else, you have to be 18 years of age when it involves property. And that's what this section is about and this part is about. We're talking about property. Talking about incapacity to manage property. So, section 6. A person is incapable of managing property if the person is not able to understand information that is relevant to making a decision in the management of his or her property, or is not able to appreciate the reasonably foreseeable consequences of a decision or lack of decision. And if you are going to be studying about substitute decision makers of different kinds, this kind of phrasing is going to show up again and again. Now, this is not about making a good or bad decision. So a person might know that if they give all their money away, they won't have any money, but the fact they're choosing to do so doesn't mean they are lacking in capacity. Maybe common sense, but not capacity. Now we're moving on to a different kind of power of attorney for property called the continuing power of attorney for property. And this is a document that is supposed to continue functioning even after the person has lost capacity. So I am drafting a power of attorney. I want someone else to manage my assets. Now I have capacity. And the plan is that even once I lose capacity to manage my own property, the person I've chosen still has the authority to continue to act on my behalf. So that's the whole concept behind continuing. So Section 7, subsection 1, a power of attorney for property is a continuing power of attorney if A, it states that it is a continuing power of attorney, so the language is right in there, or B, it expresses the intention that the authority given may be exercised during the grantor's incapacity to manage property. And by the way, someone might not lose capacity indefinitely. There might be a reason why they are currently lacking capacity, but may regain it in the future. Now, here's the thing with B. Again, we have an issue with language. If you're not specific enough with your language, then your wishes won't be specific enough, and it might be hard for the person who's acting on your behalf to actually follow your wishes. Subsection 2, the continuing power of attorney may authorize the person named as attorney to do on the grantor's behalf anything in respect of property that the grantor could do if capable, except make a will. And so the easier way to say that is, yeah, I can say to someone else, handle my bills, handle my finances, handle everything, but I can't have them do a will on my behalf. So once I've lost capacity, I can't do a will, and neither can anyone else on my behalf. Going down in the same section, but subsection 7, about postponed effectiveness. So the continuing power of attorney may provide that it comes into effect on a specified date or when a specified contingency happens. So if I have a continuing power of attorney drafted, it doesn't mean it has to start now while I still have capacity. I might have in the instructions the idea of, well, when I am deemed or assessed as lacking capacity, then that's when it kicks in. And then we have form, subsection 7.1, the continuing power of attorney need not be in any particular form. So as long as all of the legalities are honored, it doesn't matter exactly how you write it out. Okay, so I want just to direct your attention to this list because there's going to be a similar list when it comes to powers of attorney for personal care, but it's a different list, and we can think about why that might be. So, capacity to give continuing power of attorney. Section 8, subsection 1. A person is capable of giving a continuing power of attorney if he or she A, knows what kind of property he or she has and its approximate value. So can they describe whether it's like real estate or bonds or whatever? And it doesn't have to be to the, you know, absolute cent, as long as you have a vague idea. Then we can have fights over whether they actually do know what their property is worth. There's going to be a court case later, not this video, a later video where we can have a discussion about that. Anyways, B is aware of obligations owed to his or her dependents. So for example, do they have orders for child support or spousal support? That has to continue. C, knows that the attorney will be able to do on the person's behalf anything in respect of property that the person could do if capable, except make a will, subject to the conditions and restrictions set out in the power of attorney. So again, what kind of limits are there for what this person can do? D, knows that the attorney must account for his or her dealings with the person's property, and that means kind of like, are they being challenged? What's their documentation? Stuff like that. E, knows that he or she may, if capable, revoke the continuing power of attorney once they lose capacity. They can't. F, appreciates that unless the attorney manages the property prudently, its value may decline. A, and G, appreciates the possibility that the attorney could misuse the authority given to him or her. And this is the same section, subsection 2. A person is capable of revoking a continuing power of attorney if he or she is capable of giving one. So that's unnecessary. But anyways, if you have the capacity to give power of attorney, you also have the capacity to revoke it. Okay, so section 9, subsection 1. A continuing power of attorney is valid if the grantor, at the time of executing it, is capable of giving it, even if he or she is incapable of managing property. So I think that's a weird example of splitting hairs. If you can't manage your own property, how can you determine that someone else can manage it on your behalf? I do think that's very weird. And then we have subsection 2. The continuing power of attorney remains valid even if after executing it, the grantor becomes incapable of giving a continuing power of attorney. So that's the whole point. Once you've lost capacity, this power of attorney continues. So sometimes you will find that where language in statutes becomes repetitive. Okay, so warning, this subsection has some really awkward wording. I'm going to make you plow through it anyways. Okay, subsection 3. If the continuing power of attorney provides that it comes into effect when the grantor becomes incapable of managing property but does not provide a method for determining whether the situation has arisen, the power of attorney comes into effect when A. The attorney is notified in the prescribed form by an assessor that the assessor has performed an assessment of the grantor's capacity and has found that the grantor is incapable of managing property. So yeah, lots of terrible language there. The term assessor refers to particular people with particular credentials who perform assessments under this statute. And that is something we're going to be going into in another video that I will dedicate to this particular subject. B. The attorney is notified that a certificate of incapacity has been issued in respect of the grantor under the Mental Health Act. So a completely different statute. And that's one of the fun things about statutes is they make us go all over the place to find what we're looking for. It's not all in one easy place. And the Mental Health Act is also a statute we'll be looking at in another video. Section 10, subsection 1, a continuing power of attorney shall be executed in the presence of 2 witnesses, each of whom shall sign the power of attorney as witness. Now here we have a list, persons who shall not be witnesses. And so subsection 2, the following persons shall not be witnesses. 1, the attorney, so the person who's receiving the authority, or the attorney's spouse or partner. 2, the grantor's spouse or partner. 3, a child of the grantor or person whom the grantor has demonstrated a settled intention to treat as his or her child. 4, a person whose property is under guardianship or who has a guardian of the person. So for example, they have lost the ability to make decisions for themselves, so they can't be a witness for someone else. And a person who is less than 18 years old. And so one thing to notice is while they have this list of people who can't be witnesses for a continuing power of attorney, they don't have a similar list for just a regular power of attorney for property, though you do need 2 witnesses. So it's interesting to think about, why is there this difference? So the termination of the document, section 12, subsection 1, a continuing power of attorney is terminated, A, when the attorney, so the person who has the power, dies, becomes incapable of managing property, or resigns unless another attorney is authorized to act under subsection 7.5. So you have 2 or more attorneys, one dies. Well, if the others are still able to function, the power of attorney document is still in effect. The power of attorney provides for the substitution of another person, and that person is able and willing to act. C, when the court appoints a guardian of property for the grantor under section 22. And yes, we also have ways of getting that authority involving the court, and that is not a process I'm going to go into in this video, but another video. D, when the grantor executes a new continuing power of attorney unless the grantor provides that there shall be multiple continuing powers of attorney. So yeah, they have more than one document talking about powers of attorney, which seems like a recipe for complications, but I don't know, maybe it works. E, when the power of attorney is revoked, when the grantor dies. So again, this is a document that does not continue once the person giving the authority passes. And then the execution of revocation, subsection 2, the revocation shall be in writing and shall be executed in the same way as a continuing power of attorney. So it's not supposedly good enough to just say it's not effective. According to this, it needs to be written down that it's revoked. Now we reach another part, and even though they don't make it explicit in the very first section, we know because of the age and further content that this is about the power of attorney for personal care. Section 43, this part applies to decisions on behalf of persons who are at least 16 years old. Section 44, to exercise a power of decision under this part on behalf of another person, a person must be at least 16 years old. So basically, I could pick a 16-year-old to act on my behalf with my healthcare, and maybe I'm ageist. I wouldn't want someone that young. I would want someone with a lot more years on them to make those kinds of decisions. Section 45. A person is incapable of personal care if the person is not able to understand information that is relevant to making a decision concerning his or her own health, care, nutrition, shelter, clothing, hygiene, or safety, or is not able to appreciate the reasonably foreseeable consequences of a decision or lack of decision. So once again, it's not about whether a decision is good or bad. It's about this person knowing all the relevant facts and knowing the consequences, so yes, they can make that decision. Also, notice the list of activities that are relevant to this particular power of attorney. So healthcare in general, but nutrition, shelter, clothing, hygiene, or safety. And these are the kinds of things that normally fall under the power of attorney for personal care, not necessarily making decisions about whether this person has an operation or something of that sort. Power of attorney for personal care. Section 46, subsection 1. A person may give a written power of attorney for personal care, authorizing the person or persons named as attorneys to make, on the grantor's behalf, decisions concerning the grantor's personal care. And I think by now we know what this kind of language means. Subsection 3, prohibition. A person may not act as an attorney under a power of attorney for personal care unless the person is the grantor's spouse, partner, or relative if the person, A, provides health care to the grantor for compensation or provides residential, social, training, or support services to the grantor for compensation. So basically, if you're paying someone to take care of you, you're not able to make them the attorney under your power of attorney. The idea here, I think, is to protect people from being groomed by people who are working with them for money. And in another video, I'm going to talk about a case with a judge I think is really off the ball who didn't seem to think this mattered. Going down to instructions, and here we see some language that's a little similar to what we saw under continuing power of attorney for property. So instructions. Section 46, subsection 7, the power of attorney may contain instructions with respect to the decisions the attorney is authorized to make. And form, subsection 8, the power of attorney need not be in any particular form, so it has to be written, there has to be witnesses, but otherwise you can kind of do what you want. So we're going to talk about capacity to give power of attorney for personal care. And section 47, subsection 1, a person is capable of giving a power of attorney for personal care if the person, A, has the ability to understand whether the proposed attorney has a genuine concern for the person's welfare, and B, appreciates that the person may need to have the proposed attorney make decisions for the person. Okay, so here we have two elements for capacity for power of attorney for personal care. If you look back to the needs for having capacity for power of attorney for property, it goes to G. Here we have A, B here. Back there, we went down to G. That's how many categories there were. And so why would we have such a short list when we're talking about our health and safety where we live, but a much more stringent list of requirements when it comes to property? Kind of creepy, actually, I think, valuing property more over safety. Anyway. And in subsection 2 here, we see some similar language. A power of attorney for personal care is valid if, at the time it was executed, the grantor was capable of giving it, even if the grantor is incapable of personal care. So, like property, if this person can't manage their own personal care, how can they be in a position to evaluate whether another person can take care of them properly? Hair splitting, I think, is weird. And then the capacity to revoke is subsection 3. A person is capable of revoking a power of attorney for personal care if he or she is capable of giving one. So that's similar to what we got under property. And now we're going down to execution, section 48, subsection 1. A power of attorney for personal care shall be executed in the presence of 2 witnesses, each of whom shall sign the power of attorney as witness. And then persons who shall not be witnesses. Subsection 2. The persons referred to in section 10, subsection 2 shall not be witnesses. So they're not going to put it down for us for easy reference. We have to go up to section 10, and some statutes are really long. So that is fine if it's online and the text is short, but sometimes you need to go to actual paper versions of a statute because they'll have all sorts of explanations about how it's been interpreted. So if you have to like flip around from one section to another when it's this huge paper text, it's a real pain. This will sound kind of nonsensical to you at this point, and again, the joys of having to read through stuff designed by politicians. So when power of attorney effective? Section 49, subsection 1. A provision in a power of attorney for personal care that confers authority to make a decision concerning the grantor's personal care is effective to authorize the attorney to make the decision if A. The Health Care Consent Act 1996 applies to the decision and that act authorizes the attorney to make the decision. Okay, when we get into Healthcare Consent Act, we're moving a little away from the things about, safety, where they live, feeding them, into decisions about treatment. So, for example, treatment from a doctor, maybe something like an operation, what have you. So, I don't expect you to really understand this right now. I am going to be talking about the Healthcare Consent Act in a different video. Anyways, B, the Healthcare Consent Act 1996 does not apply to the decision, and the attorney has reasonable grounds to believe that the grantor is incapable of making the decision, subject to any condition in the power of attorney that prevents the attorney from making the decision unless the fact that the grantor is incapable of personal care has been confirmed. Wow, that is really messy. And I just put it there to make the section complete, but I don't expect it to make sense to you right now. Hopefully it will in a later video. But that is the end of this very long video, and thank you for getting to the end. Have a great day.